courtroom. I'm Mr. Barnett at the District Attorney's Office. We sent this matter over for a pretrial readiness conference. We're set for trial on March 12th at 8 a.m. Ms. Real, I see that you're still representing yourself in this matter. Is that correct?
I would like to invoke my right to remain silent.
All right. Mr. Barnett, anything from the state we need to take care of?
No, Your Honor.
All right. We're set for jury trial on March 12th. And we'll come back one more time for a pretrial readiness conference. I did issue a case management order in this case on November the 3rd. Ms. Real, you are required to comply with that case management order. I do want to ask you a couple of questions just to make sure you understand that you do have a right to represent yourself. I understand that you've typically just stated that you want to exercise your right to remain silent, but I want to go over this with you. You understand that the allegations that you're facing are up to a Class 1 traffic offense, which is up to 364 days in the county jail. That is the maximum penalty on that charge. How much education do you have, Ms. Real?
I would like to invoke my right to remain silent.
All right. Do you understand that there are legal complexities in this case that ultimately that even though you're representing yourself, that you're going to be required to under the same standards, rules of evidence that the district attorney would be under. Do you understand that? Do you understand that,
I
Ms.
would
Real?
like to invoke my right to remain silent.
Ms. Real, this has nothing to do with your innocence or your guilt. I'm trying to determine whether or not you're capable of even representing yourself. I've been very, very patient with you. You haven't even stated your name. I'm not even quite sure that you are Ms. Real. I called Ms. Real to come up here and you stand up here. And so I'm basing on that an assumption, I guess, that I'm making. But I have to establish certain things to make sure that you understand what you're faced with here. You have a right to remain silent of anything that might implicate you in any sort of criminal activity, whether or not you've gone to schools that are making it's called an Arguello advisement, so we refer it to. It's to make sure that you understand that I know that you're competent to represent yourself. Do you want to represent yourself in this matter?
I am invoking my right to remain silent.
All right, I'm going to take that as a yes. You understand, obviously, you have a right to remain silent. Finding that you can represent yourself in this matter. We're going to go ahead and continue on with the jury trial. We'll set this for one more pretrial conference. Mr. Waldo, Mr. Barnett.
Before we even get started, buckle up, because today's video is a masterclass in what happens when confidence outruns competence inside a courtroom. What you're about to see isn't just one sovereign citizen meltdown, it's two separate defendants, two very different cases, and the same dangerous mindset playing out in real time. One defendant thinks invoking the right to remain silent means she can derail basic court procedures. The other believes she can show up whenever she feels like it, to a felony case carrying star, and here's the twist, neither judge loses control of the courtroom. Instead, you'll watch calm, methodical judges do something far more devastating. They let the record speak for itself ****. Every contradiction, every scripted phrase, every moment where the defendants unknowingly make things worse is captured on the record, forever. Pay close attention to how the judges handle jurisdiction arguments, fake Latin claims, refusal to answer basic questions, and repeated attempts to avoid acknowledging reality. Because by the end of this video, one thing becomes painfully clear: the law doesn't care about internet script.
I do not speak Latin.
Okay.
I do not know the Latin language. Am I in your commercial jurisdiction?
Ms. Real.
Or,
okay.
let me speak.
Okay, if you want to speak, yeah, go ahead.
Am I in your commercial jurisdiction? Are you going to give me an interpreter? I still do not understand. I don't know what's going on. My freedom is at stake. I have the right to counsel. My freedom's at stake. You charge me a fee. You separate common law to my freedom with commercial law, where you impose a fee on me.
All right, so Ms. Real, I'm going to interrupt you. Ms. Real.
It both ways.
Ms. Real, I'm going to interrupt you now. So do you,
Which
Ms.
jurisdiction
Ms. Real, if you don't stop, I'll hold you in contempt and I'll put you in custody. Stop. You clearly understand the English language, and I'm speaking to you in English. Do you need an interpreter in another language? Because I'm not speaking in Latin. I'm speaking in the English language. You just stated to me that you have a right to counsel. Would you like an attorney appointed to represent you?
Can I finish speaking? Can I finish speaking?
What do you need to say, Ms. Real?
Okay, then I am invoking my right to remain silent. If I cannot speak, then I am invoking my right to remain silent.
Things already start going sideways, and it's an important moment to understand. The judge isn't asking questions to trick her or extract a confession. He's legally required to determine whether she's competent to represent herself. That includes basic things like education level, understanding courtroom rules, and whether she grasps the seriousness of the charges. Invoking the right to remain silent doesn't magically pause that obligation, and here's the irony. By refusing to answer non-incriminating questions, she's not protecting herself, she's actually hurting her own position. The judge is being patient, careful, and crystal clear, but the defendant keeps repeating a phrase she clearly doesn't understand. Silence is a shield against self-incrimination, not a cheat code to avoid procedure. And when you refuse to cooperate at this stage, judges are allowed to draw practical conclusions, not about guilt.
And I'm not speaking to you in Latin, Ms. Real.
Am I in your commercial jurisdiction or am I under your common law jurisdiction of the Constitution? You compromise me in every single way when I come into the courtroom. You strip me of my right to bear arms by running me through a metal detector, already compromising my rights as an American. You force me into a room where you have sentries with body armor, guns, pepper spray, tasers. You sit me down in a chair and then you ask me if I understand. No, I do not understand. You violate me through and through, and then in the middle of the game, we get halfway through the hearing, you change it, and then you spark out some word in Latin, and I am sitting here confused as all heck, asking me if I understand. If I don't put it up and tolerate with your actions, you will have your officer standing up against the wall, pull out his weapon to scare me and throw me in a dog cage. You are acting criminal, corrupt, and evil and demonic. I do not understand, and therefore you cannot form jurisdiction over me. You speak a foreign language that is regulated from Britain.
Okay,
In
Ms. Real,
America,
that's
in
enough.
America, you
Ms. Real,
speak English to me.
Ms. Real, that's enough. I've heard enough. Okay, so you obviously understand the English language. Okay, so you are under the jurisdiction of the court. That is the jurisdiction that you are under. You are in the Conejos County Court. I am the Conejos County judge, and I do have jurisdiction over you.
Can I finish?
No, you cannot. I'm not going to continue to listen to this. This is what we're going to do. You are set for trial on March 12th. You will show up here for trial on March 12th. If you don't show up, I will issue a bench warrant for your arrest. We are going to have a trial March 12th. You have the right to counsel. If you would like to apply for counsel, you clearly understand that because you just told me that you have a right to an attorney. There is an application right there on that table. You can fill out that application and you can provide that to the public defender's office. They can enter an appearance for you free of charge if you qualify. That is your right to an attorney. If you don't want to apply, and that's absolutely your choice, you get to elect that. But we are going to trial on March the 12th, and you will be here for trial on March the 12th, and we will put it to a jury, the allegations against you. That is what we're going to do.
Okay, well then, can I get that in writing?
You have it on the record. We'll be here March 12th for a trial.
What time is that?
Start at 8 a.m.
All righty.
We won't need to come.
Ah yes, the infamous Latin argument. This is a classic sovereign citizen trope, and it collapses instantly under even mild scrutiny. No one is speaking Latin. No magical spell has been cast. What's happening is that the defendant doesn't recognize legal terminology, so instead of asking for clarification, she jumps straight to claiming oppression in foreign jurisdiction. Notice how the judge handles this: calm, direct, and firm. He doesn't argue philosophy. He doesn't debate conspiracy theories. He brings it right back to reality. This is English, this is a courtroom, and these are your choices. And when she keeps escalating, the judge warns her clearly about contempt. That's not intimidation, that's the court maintaining order. Judges don't need your consent to exercise jurisdiction. They need authority, and that authority is
Only 103. Miss Mayberry does not appear. I'm going to give her to 105, and then we're going to move forward. Ms. Becker, can you remind the court, has there been any failures to appear in this case?
Your Honor, I was just looking at that. We did have ones early on, and she did have to be extradited from Texas. But she has been since on bond and in Colorado and appearing for the last several. Our last FTAs weren't since August of 2023. She also has a revocation matter in Adams County. She did appear at their last hearing in October of 2025. And then I just checked Vine Link and she does not appear to be in custody.
Okay.
Give her to like 115.
Okay. All right. We'll wait 10 minutes. All right. We're back on the record in 23 CR 884. I'll note for the record that it is now 1:20. This matter was set at 1 p.m. Ms. Mayberry does not appear.
Given that there was the older FTA, the age of this case, and that we have had to extradite her from Texas, I do think the 20,000 cash surety is appropriate. She also has somewhat of criminal history for VPOs primarily, and some other trespass to dwellings. So also a history of not complying with court orders, which is also why I'd asked for the 20,000 cash surety.
All right. What the court's going to do, I'm going to find that Ms. Mayberry has failed to appear. I'm going to revoke her bond. Court's going to issue a warrant. Court will set a new bond in the amount of $20,000 cash or surety that is based on Ms. Mayberry's prior history of failing to appear, as well as her criminal history and the severity of the underlying charges.
And just when you think you've seen peak courtroom chaos, we move on to our second case, and this one is far more serious. This isn't a traffic matter. This isn't a paperwork dispute. This is a felony burglary case, involving a home invasion, stolen firearms, and an identification made minutes after the crime. The stakes here are real, and the potential prison time is massive. What immediately stands out is the pattern: missed court dates, extradition from another state, prior failures to appear. Judges don't forget those things, and neither do prosecutors. So when this defendant shows up late, again, she's not just inconveniencing the court. She's reinforcing every concern the state already has about her reliability. Courts are patient, but patience has limits, especially when
Ms. Mayberry, you need to be there right at 1 p.m. Court's going to call at 1, and we're going to move forward. Court will quash the warrant that was previously issued. Ms. Becker, is there anything else? Any discovery updates?
Thank you. Your Honor, I did want to alert the court. I did provide Ms. Mayberry a copy of all of the discovery in this case today via a USB. I also had her sign a document noting that she's received that discovery. It does have all the both media and the PDFs in this case. I did also get a good email address for her today. So if there are any trial preps that create potentially new discovery that we usually create around trial preps, that would be the only thing we would be emailing her new. Otherwise, all the discovery is in. And then lastly, the people did just want to make a brief Lafleur record.
Yeah, please go ahead.
Thank you. Ms. Mayberry is charged with a Class 3 felony for burglary that has the possibility of 4 to 24 years in the Department of Corrections. It is, we do consider her enhanced due to a case being open at the time, which is Adams 20 CR 4209. That's what makes the enhanced range 4 to 24 years. She is still probation eligible, even if convicted at trial. The offer on this case was to a Class 4 felony for burglary in the second degree and a Class 5 felony for palpo, which is possession of a weapon by a previous offender. That is also the enhanced range with the possibility of 2 to 12 years and is still probation eligible.
Okay. Ms. Mayberry, do you have any questions about that?
Just the verbiage,
Okay. What part of the verbiage?
all of the verbiage of it.
So let's, I guess, break it down then. Ms. Becker, the offer is to,
It would be for a slightly lesser felony. It's still called a burglary in the second degree, but it's one step down. That's why you go from a 4 to 24 range to a 2 to 24. And then a class 5 felony for palpo, which we would, if she was sentenced on both the F4 and the F5 palpo, we would ask for a sentence together in that range of 2 to 12 years.
Okay. And the palpo is possession of a weapon by a previous offender. So if you proceed to trial, the potential sentencing range that the court can impose is 4 to 24 years. The offer is a plea to a charge which would set the sentencing range from 2 to 12 years. Okay? Because we're proceeding on this case, the district attorney is making this record because there's not going to be any further offers. We're going to proceed to trial on this case. Do you understand that?
Yes, Your Honor.
Okay.
The people don't object to a bifurcation. I do think that makes sense to do the palpo and the VPO after the other 2 charges. And for defense 8 for the motion to eliminate, the people would not be presenting Ms.
5 minutes?
Yes. I told you on Tuesday that I wasn't going to have you late for today's hearing. You need to be on time.
I have to take public transportation, Your Honor.
I told you about this hearing on Tuesday. You could have made arrangements to be here on time.
And yes, I did.
And
Got
you were
here
late.
As soon as I could, Your Honor.
Okay. What I'm going to say, Miss Mayberry, we're set for trial. If you are going to be late for any of those trial dates, I'm not going to keep the jury waiting for you. I will remand you into custody for the trial if we need to do that to make sure that you are here on time. Okay? We have people waiting. You need to be on time. We're going to go forward. Ms. Becker, we're going forward on the defense's motion to suppress show up identification. Are the people prepared to proceed?
Yes, Your Honor.
All right.
This is the moment where reality crashes in hard. When a defendant fails to appear, judges don't have the luxury of assuming good intentions. They look at patterns, past behavior, criminal history, and risk of flight. And here, the court lays it all out: prior extradition, previous failures to appear, and serious underlying charges. That $20,000 cash bond isn't arbitrary. It's a direct response to demonstrated risk. And while the warrant eventually gets quashed when she shows up late, the damage is already done. The record now reflects unreliability, and that matters later, especially at sentencing. Court isn't just about what you say, it's about whether your actions match your words. And right now, those 2 things are nowhere near aligned.